Hey everyone, it is Rob Ryder, and today our special feature is Acts of Naughty Notaries, starring judges, bankers, title company workers, sworn officers of the law, court clerks, barflies, politicians. Observe evidence of their participation in crimes whose sentence in the past would have been stoning them at the city gates. Because we're a bunch of liars in the Old Testament, we've been breaking a commandment, thou shalt not lie. That should have got you stoned at the city gate. Yeah, they'd stone you in the Old Testament for arguing with your son. Or you should stone your son for arguing with you at the city gate. So, now, it's more like official misconduct, perjury, things like that. They provide the dirty laundry in evidence that we're going to take a look at, and we need to determine where to air it out. Looks like it's a Secretary of State's a really good place to start. That to be worked out yet. And I am Rob Ryder. Court of Record AOL.com is my email address, and my phone number 616-712-6179. If you would or could or want to get an update when these videos happen, you should sign up at robcourtofrecord.wordpress.com. Again, I used to send all this stuff out by AOL. AOL's made it too difficult to do. I can't do it anymore. But if you subscribe there, when I go to robcourtofrecord.wordpress.com, then when I post it there, you'll get you'll get a notice that I posted a video. Whatever it happens to be. It's up to y'all. Donate! Yes, I have to ask again. Look at that date. Today is September 27, 2014. I got to have about $900 at the end of the month, and I got, let me look in this drawer, $211. Could use some help. PayPal name for the PayPal account is my daughter, which is Ashley Ritlewski at gmail.com. Snail mail to myself. Pause it for a second, write those down. Please send a donation. See if we can make this worthwhile. So because we're talking about acts of notaries, well, what is a notarial act? It means any act that a notary public commissioned in this state is authorized to perform, including but not limited to the taking of an acknowledgement, the administration of an oath or affirmation, the taking of a verification upon oath or affirmation, and witnessing or attesting a signature performed in compliance with this act, and the uniform recognition of acknowledgments, acts, blah, 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 blah. So that's what this is based on. And then coming soon, because there was just too much to do in one video, is that your final answer? And that has something to do with, well, let's just look at one. This is the IRS and political subdivisions / municipal corporations that aren't what they say they are. So for instance, this is a W-9 for a Forest Preserve District of Kane County. It's part of the county government, so it says. Gives us address, has an EIN number, 38-376739. 6. Okay. And there's nothing wrong with that. Or there could be, because is this really the name? Or is that a DBA and the real name is something else that should have been put down here, but they didn't do that? I don't know. What I do know is if you read this part 2 on a W-9, you'll see that whomever did this signature just committed perjury. Because the damn paper says, under penalties of perjury, I certify that the number shown on this form is my correct taxpayer identification. Or I'm waiting for a number to be issued to me. And, okay, so we really don't need to go any further. So, what is a U.S. person? Because it said, okay, here we are, number 3. I am a U.S. citizen or other U.S. person. Defined below. What is a U.S. person? Because see here it's asking for the signature of U.S. person. Didn't say signature of U.S. citizen. It said signature U.S. person. Nevertheless, what is a U.S. person? An individual who is a U.S. citizen. Oh, okay, I guess that could work. But it's also a partnership, a corporation, a company, an association, or an association created or organized in the United States under the laws of the United States. Well, anything that's associated, like organized, letters of association, letters of organization, would have been like a city, town, county, political subdivision, whatever. An estate, domestic trust. Okay, so either, now there's other paper where this forest district is claiming that this is their number, right? And this guy is certifying that either this is his number or he's waiting for a number. But he's really not waiting for a number, because you could use your Social Security number, as you can see. So he has a Social Security number, so we can't say that he's waiting for a number. No, you have a number already. You should have put it up there in the Social Security block. So this guy, who should have put, what should be here in part 2, signature U.S. person, where it looks like starts with a K, is the seal of this organization here called the Forest Preserve District of Kane County. And they do have one. Seen it before and showed it in the last video. They have a seal. Well, a signature is a corporation's, or excuse me, a seal is a corporation's signature, right? So it should have been a seal put on there, and then like a by with whoever is representing the organization, because I have no idea who this guy is that scribbled his name, but whoever it is, it's just committed perjury on a IRS tax form. And so I took this and some other information, and I've been sending complaints in the last week. Now I didn't pick up on this perjury being committed until the last one I sent, which I did on Friday to a place called the Federal, State, Local Government Division, organization, I don't know, in the IRS. They have people that are supposed to make sure that federal, state, and local government entities follow the tax laws. Actually, I think it just says follow the law. Well, somebody just committed perjury on one of their forms, right? So there's a reason to investigate. Don't need to go any further, although I did, and that's what the next video will be about. But I'm just telling you right now, go get your county, whoever, right? You do it by Freedom of Information Act, and whatever you think your county is, or your city, or the police department, or the court, whoever, send them a FOIA, tell them you want their EIN number. And if they tell you they don't have one, right, they're part of something else that does, then say, well, then tell them I want your the EIN number, that notice to agents, notice to principal. Whoever your principal is, right, I want the EIN number. When they send you this W-9, see this W-9, right, it's request for taxpayer identification number and certification. That's what I want. I want to identify the taxpayer and certify the number. That's what I want it done for. Now this is what you're supposed to do before you give them a donation, right? This is the whole reason for this form, really, is if you don't certify, you as the payee, maybe the payor, and you, let's say you want to give this political subdivision, which is claiming to be municipal corporation, you want to give them a donation, right? You need to make sure that they're tax exempt, because if they're not, you were supposed to hold back 28%, and that has to do with backup withholding, they call it, I think. enter your TIN in the appropriate box. The TIN provided must match the name given on the name line to avoid backup withholding, which is like 28%. Right? For individuals, this is your Social Security number. So again, if this guy here wanted to say this was for him, he would have put his Social Security number here and then put his all caps up here. Because the all caps is tied to the Social Security number, and the all caps, of course, is your property. Claim it, tell them it's yours, ask what they want to do with your property. That's what we're doing. You don't run away from it, it's your property. But this Forest Preserve District is saying this is their property, that this number is, and somebody else just signed for it, and that's perjury. That's what I said, so I sent out one of a number of different complaints last week. We'll see if anything happens. We're not really talking about that today. That's yet to come. What we're going to talk about is notary stuff. And let's see where a good place to start on that might be. So what we want to see is if this official seal, and blow it up a bit here, Kenneth J. Sison, right, who's doing this as a notary, because this is his notary seal, has properly certified this complaint that's supposed to be basically a statement under oath, right? It'd be an affidavit at the end of the day, because all oaths rendered to writing are affidavits. Or on this oath of office for a judge, which the seal here says it's the seal of the Supreme Court, I think it says. Seal of the Supreme Court. Did this Judith M. Brokaw, who says she's the chief judge, doesn't say the chief judge of what, so you would have to assume by this piece of paper she's the chief judge of the Supreme Court. I'd say that's, you know, some kind of official misconduct, impersonation of an officer. That's what it is. So the undersigned being authorized to administer oaths certifies the foregoing oath of office was administered to the declarant on this day. Right, she's acting as a witness. Right, but did she do a proper certificate? Is this right here what the law, notary laws of Illinois say it has to be? Well, let's go take a look. Oops. Sorry guys, I got pushed too many buttons here. So the Illinois Notary Public Handbook. Jesse White, Secretary of State. Jesse, how are you? What did your book have to tell us? You know, because this act is pretty much the same, although it's not exactly the same. Like we're going to see here in Illinois, they have to use a seal. In Wisconsin, they don't have to use a seal. But the term notary public and notary are used interchangeably to mean any individual appointed and commissioned to perform notarial acts. Notarial acts, I guess. And that's the important thing, is this, I'm going to call them notarial acts because that's how I'm used to saying it. But right, if they're doing a notarial act at that particular moment in time, they're doing it as a notary. Doesn't matter if they're an elected officer of a judge. It's not a judicial act, it's a notarial act, and notarial acts are done by notaries. That's simple. So, right, when this judge down here did this, she's doing it as a notary, so she needs to file, because it's a notarial act, to witness this this oath of office. And let's get back to where was that? Okay, so appointment application, blah, blah, blah. They need to take an oath, solemnly swear and affirm under penalties of perjury that the answers to all questions of this application are true, complete, correct, and I have carefully read the notary law of this state, and that if appointed and commissioned as a notary public, I will perform faithfully to the best of my ability all notary acts in accordance with the law. The appointment of an applicant as notary public is complete when the commission is recorded with the county clerk. So all the other stuff that they're doing ahead of time is for naught, even if they pass the test and they get the commission, until it's been recorded at the county clerk. Right? And that's because the person who's getting it has to go there and pick it up. And so what it says here is the records of the office indicate that you have not picked up your notary public commission from the office of the county clerk. The Illinois public law requires you to appear in person in the clerk's office, and pay a fee of $5 to the county clerk or request that your commission be mailed to you. The request must be accompanied by a specimen of your signature and a $10 fee payable to the county clerk. Your appointment as a notary is not complete until the commission is recorded with the county clerk. I should also like to remind you that any person who attests to any documents as a notary and is not in good standing in the office of Secretary of State is guilty of official misconduct and may be subject to a fine or imprisonment. Well, I don't know why I keep hitting that one. So we went to the county of Kane and asked the county clerk if Judith M. Brokaw is registered with the county and as a notary. And she wasn't. Well, that's interesting. She's not a notary. Then how can she be doing a notary act? Now, it could be that she's a notary in another county and doesn't have it moved here, but that would mean that she's claiming that as her residence, this other county, and she's supposed to be the chief judge of this county, and I believe she has to have her residence within the county. It's official misconduct. So we're working towards. Going to make it official misconduct. At the time of the notarial act, a notary public shall officially sign every notary certificate and affix the rubber stamp seal clearly and legibly using black ink so that it is capable of photographic reproduction. Affix the seal. Right? That's what this guy did. Right? He affixed the seal. But the judge, he has no seal. There's been no seal affixed. And in the state of Illinois, it just said, affix the seal. Probable cause for an investigation, because there is no seal. Okay. Got a few more things here. This one. Certificate of authority. So let's say they've done it right. Right now, this is those who follow me, we know what the certificate of authority is. Right? It's what you get from the clerk or whomever that certifies that the notary was a notary when they were doing what they were supposed to be doing. And it's a witness for the notary that the notary is in the book and they are a notary in good standing with the Secretary of State, blah, blah, blah. So upon the receipt of a written request, the notarized document, and a fee of $2 payable to the Secretary of State or county clerk. It's interesting, Secretary of State or county clerk, why it would be one or the other. Is that the same person with two different names, or we'll find out. The office of Secretary of State or county clerk shall provide a certificate of authority in substantially the following form. I, yada yada, yada yada. In the state of Illinois, and as such, full faith and credit is in and ought to be given to this notary's official attestations, the testimony whereof I have fixed my signature and seal of this office. Okay, and we'll be looking here soon. So Roe went down to get one for something that she had done by a notary at a bank, And when she got the certificate, it doesn't have full faith and credit in it. But here the Secretary of State is saying it should have this, right? Substantially in the following form. Well, the substance of this whole thing is a full faith and credit. You take the faith out, it has no substance. And on the one she got, they didn't. And there are a couple other strange things that happened on there we'll take a look at. Okay, notary acts and forms. A notarial act means any act that a notary public of the state is authorized to perform and includes the taking of an acknowledgement, administering an oath or affirmation, taking a verification upon oath or affirmation, witnessing or attesting a signature. Right? If you're administering an oath or taking a verification upon oath, you're doing it as a notary. If you're doing it as a notary, it's a notarial act, and a notarial act requires the person doing the notarial act to use a seal. In this oath of office, there is no seal, so this is official misconduct. So we called it and we sent it in. Okay, let's continue on. Certificate of Certificate of Notarial Acts. A notarial act must be evidenced by a certificate signed and dated by the notary public. The certificate must include identification of the jurisdiction in which the notarial act is performed and the official seal of office. It's okay if it's in the short form set forth in the section we're going to come up to here in a bit. They also have a form. So what Roe did is she said, I want you to certify this. I want you to do the notary as it shows, as it speaks of in the Illinois Notary Handbook. She told that to the guy at the bank who normally just writes on the thing that we put at the bottom, whatever words we come up with. And as soon as he said that, he looked at her and he went back and he got another form. And that's what he used, right? Because she wants it done by the book. He's going to do it by the book. He went, apparently, find out what the form was he was supposed to use. Although he committed perjury on it. We'll look at that in a minute. He did go get the form to use. A notary shall not, these are acts prohibited, shall not use any name or initial in signing certificates other than that which the notary was commissioned. And it looks like when they normally do it, they want you to use the middle initial. Right? Kenneth J., he did his that way, and Judith M., I mean, she did hers the way it should have been on a seal, but there's no seal on here. Judith, where are you a notary at? Do we need to go ask the Secretary of State to find out where your commission is? I can do that on a Freedom of Information Act. Or we just call it disclosure. All right, so here's a bunch of things they can't do. There's any number of them. Not, thou shall nots. But this is what these short forms are supposed to look like. For an acknowledgement in a representative capacity, for verification upon oath or affirmation, which, let's just say this, the one we're trying to stick with. Or it could be this one, signed and attested. Right? Signed and sworn or signed and attested. Well, what's the difference? Attested means you're swearing to it. Date by signed and attested before me on, or signed and sworn to before me on date. There really is no difference, is there? But it has the state of and the county of, and then it has a little blurb, then it has a place for the notary to sign, then it has a place for the seal. And this little certificate would, be at the bottom of the page, not part of the oath, right? So not part of the description of what they're talking about. And so, anyways, this doesn't have state of or county of on any place, right? So this is improper. How about this other one? Foregoing complaint was subscribed and sworn before me on the, okay, yeah, if you want to say that's okay, but where is the jurisdiction that this is in? Kenneth. All right, it should be state of and county of. Because that's written, you know, a lot like this thing down here attested before me. So again, it doesn't seem to be done right. It just doesn't seem to be done right. Right, judge or notary public. Ain't that something? Kenneth J. Sisen. It's his official seal. Yeah, but it doesn't have the jurisdiction he's working on in here. So Kenneth J. Sisen just, you know, he committed official misconduct as a notary. He's in good hands, though. So did the chief judge of the county. She committed an official misconduct as a notary. What else is there? Well, the employer of a notary public is also liable to persons involved for all damages caused by notary's official misconduct. Now let's think about this. Who's the employer of the judge? The county is. They're considered common law employees of the jurisdiction they're working for. The municipal corporation, the political subdivision, whatever. But they're common law employees. And so, did the employer consent to the notary public's official misconduct? Because this ain't very hard to figure out, right? Let's go back to old Judith here. If Judy didn't do this right, then Betsy isn't a judge. And anything Betsy has done since she's been a judge, as far back as we can go, would have to be undone, because she was never a judge. She never took an oath. Never had a proper oath administered to her. And the chief judge of the county, or the chief judge who's been appointed by the Supreme Court to be over the county, I think is probably better put. I think the chief judge is appointed by the Supreme Court. Because really what the chief judge is, they're the circuit, they are the court clerk. Well, let's say court administrator. But I'm going to say that could be the court clerk too. Right? That's who they are. Their job is to administer the court system. They don't sit in court. They sit in the office and they administer. So they're the chief administrator of the court. Well, their employer, the Supreme Court, put them in there, and, you know, this paperwork has gone into the Secretary of State's office and nobody seems to have a problem with it. So apparently the employer's got something they need to worry about. Right? Official misconduct. The term official misconduct generally means wrongful exercise of a power or the wrongful performance of a duty. And it is fully described in Section 33.3 of the Criminal Code. It's a criminal act. The term wrongful is used in definition of official misconduct. Means unauthorized, unlawful, abusive, negligent, reckless, injurious, right? So it was a wrongful exercise of power because Judy, our supposed judge, didn't use a seal, and she's not in the book in the county as being a clerk or as a notary to do anything in the county. And she didn't fill the paperwork out properly. Pretty simple. It's notary misconduct. It isn't judicial misconduct. Now, see, here's the thing. So what we're going to point out, no, this is a notary misconduct. It's a notarial act done improperly by a notary. Somebody acting in the office of notary. Willful impersonation. Any person who acts or otherwise willfully impersonates a notary public, while not lawfully appointed and commissioned to perform notarial acts, is guilty of a Class A misdemeanor. So we're going to see if old Judy has a frickin' oath or is a notary public anywhere within the state. If not, that was willful impersonation, and she's done it on every judge's oath that's in the, that's under her. Wrongful possession. Actually, at least she didn't use the seal. Now, the other dude that we looked at on the complaint for against Roe, he is in the book as being a notary. What else we got? Official seal. Sarah I. Doe would be correct. Sarah Doe wouldn't. Seems to me on my taxes, federal taxes, they use my middle initial too. I just wonder if that's the sign of a particular jurisdiction. If a notary is commissioned in John M. Doe, that is the name that must appear on his stamp and must sign his name that way. So I guess we need to look at their commission and then make sure that they're, because you can get the commission, right? Again, it's just public record. Say you want the guy's commission. Why? Well, because I have a material interest in the matter. That's why. Signing as J.M. Doe or using other variation is not acceptable. Whatever's on the commission needs to be on the stamp. Okay, sample forms. We looked at this. I don't know that I had any more on this one. But you get the idea, right? It doesn't look. Last thing, your notary commission is not complete until you are registered with your county clerk's office. To access information of the county clerk in Illinois, please visit one of the websites below. So again, if old Judith here is not commissioned in this is Kane County, right? But she's commissioned in a different county, and that's what she's claiming as her residence, then how can she be the chief judge of this county? Because I believe if you go look in the law, she's going to have to be a resident of the county to be the chief judge. And the house of cards comes tumbling down. Okay, let's look at some other things. Now, notary requirements. From Arizona, record book required. The notary must keep only one paper journal at a time, unless some entries are public records and some are non-public. If that is the case, two separate journals, one for each type of record, may be maintained. Interesting. It's talking about, notaries don't just do public records, they do non-public or private records. Well, if you're trying to create a public record, then you want it to be in the public record book and not in the private record book. Well, how would you know the difference? Let's continue on. If one or more entries in a notary public's journal are not public records, the notary public may keep one journal that contains entries that are not public records and one journal that contains entries that are public records. So the first thing you do is say, I want to be sure this goes into your public record book, because it could be they could have two books. A notary public journal that contains entries that are not public records is the property of the employer of that notary public and shall be retained by that employer if the notary leaves that employment. A notary public's journal that contains only public records is property of the notary public, without regard to whether the notary public's employer purchased the journal or provided the fees for commissioning the notary public. So, we're going to the bank or to the title company or whomever we go to get our stuff notarized, but unless that book is the property of the notary public, him or herself, it's a private record. It's not the public record. We need to make sure that it's going into that when they're done, we have a public record, because we want to get the certificate of authority attached to it, which then gives it full faith and credit according to the Constitution of the United States of America, for all your public full faith and credit to all public acts, records, and deeds. Something to that effect. Right? But if you did it as a private record, then it doesn't matter if you get that on there because it wasn't a public record to start with. And what's the difference? The public record book belongs to the notary. The private record book belongs to the employee. You go to the bank and they bring the bank's book and do it, then that was a private record. They just never told you. And I think that's what they did to Roe, even though she went and said, I want you to do it by the book. Because they got a little bit, you just have to wait and see. Make sure it's a public record book. Ask the notary, do you have a book just for public records? That's the one I want this in. I want this done as a public record so that I can go when I'm done to get a certificate of authority from you so that my document has full faith and credit according to the Constitution of the United States of America. I'd even go this far and say, is there, because here's the other thing, and I don't know if I have it in this. You have a right to get a certified copy of the page they put in the book. And I was looking at some notary supplies today, and I'm not an expert in this stuff, or yesterday. I'm far from an expert, but I'm just kind of looking and say, well, here's something that looks like a receipt they would give you, and it has, it wasn't a book and page number, but it was a reference number of 8-9 digits. And it's like, wow, I've seen numbers like that on people's foreclosure things or on their warranty deed or things that had to do with a foreclosure, right? It's like I always wonder where these handwritten numbers came from. I'm sure now that that's probably an entry in somebody's book. And it would be really good information to get if we could figure out how to get it. That's out of the notary book, right? And so I think that that's what's making it a public record, is the fact that they wrote on the instrument itself this tie back to the book and page that it's in or the registration number or whatever it is. And that's, we need to get them to put book and page on our paperwork. Or something is missing from the start and it's with the notary, and it's just so simple that if we didn't make it a public record, it's a private record because it's in a private book, well, okay. The thing is, that isn't what a public notary public's job is. They may work for an employer, but it's an office, as we'll see, of the state, and they have a duty to the people of the state. Okay, this is in Texas. Requires a notary public to maintain a record book. Not all states do. I believe in Michigan they don't require it. A notary public, other than a court clerk notarizing instruments for the court, shall keep in a book a record of the date, the name, whether the signer, grantor, blah blah blah, things they would do. I guess my point with this is it's just showing now that a court clerk is a notary. A notary public other than a court clerk. Right? So a court clerk is one type of notary. Now here's some interesting things out of California. Willful failure to perform a duty or control notarial seal. Any notary public who willfully fails to perform any duty required of a notary public under the section, who or willfully fails to keep the seal of the notary public under the direct and exclusive control, who surrenders the seal, blah 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 blah, is guilty of a misdemeanor. Now Roe had gone to her county clerk before and wanted them to notarize some paperwork, and they wouldn't do it. Right? They didn't want to be the witness. They said, no, we can't do it. We have a certain way we have to do it, or something like that. Of course, these are things we heard before that thankfully people remember and they bring up against it. Oh, you know what that means? They're going to have to do it properly. And you're going to go into them and say, any notary public who willfully fails to perform any duty required of a notary public is guilty of a misdemeanor. Right? So, one of the things that's going on this week, it's been FOIA time. Putting FOIAs into the county clerk to find out if the clerk of the court has a notary seal, is a notary. Right? Because that clerk of the court seal is on everything. Well, if that dude isn't a notary, then everything that he touched has been done improperly. Right? If he's not a registered notary, in the county. Same with the county clerk. Same with the register of deeds. Same with all these elected officers. Same with the sheriff. Find out who has a notary certificate somewhere in the state. No officer of a county or judicial district will charge or receive any fee or compensation for administering or certifying the oath of office or filing or swearing to any claim, blah, blah, blah. I guess the reason I put that in there is because oath of offices are within this notary law of California, I guess. This came out of the, see, this is out of the California Notary Handbook for 2013. Notary public. Officers before whom proof or acknowledgement may be made. The proof of acknowledgement of an instrument may be made before notary public at any place within the state or within the county, city, county, in this state, office specified below, right? So what's saying is all these people here are notary publics. The clerk of the Superior Court, the county clerk, the court commissioners, retired judges, district attorney, clerk of the board of supervisors. They all can perform notarial acts, make them do it, because some of these people, I mean, if we make them, tell them they're going to have to do it, they're going to do it properly. And I believe that was what would happen with the county clerk that Roe went and talked to, or the clerk of the Superior Court, which is the same as the clerk of the Circuit Court. It's saying right here, he needs to be a notary. Offices authorized to administer oaths or affirmations. Every court, every judge or clerk of any court, every justice, every notary public, and every officer or person authorized to take testimony in any action or proceeding or to decide upon evidence has the power to administer oaths or affirmations, which is a notarial act, so it needs to be done as a notary, and you better have your damn seal on it. So yeah, the judge can do it. He can take the oath of Betsy, the other judge, but he needs to put a seal on it, because it's an act of a notary. Improper notarial act, solicitation. Any person who solicits, coerces, or in any manner influences a notary public to perform improper notarial act, knowing that the act to be improper notarial act, including any act required for the notary public under 8206, shall be guilty of a misdemeanor. And this is when them son of a bitches start pointing fingers at each other. He told me to do it that way. No, it's his fault, right? This is when they quit coming after you and they're going to go after each other. Right? Get them in a bind with the law looking at them, and they're going to start pointing fingers. I was told to do that. At the end of the day, hey, you're all forgiven. Just ask forgiveness. We'll go back to, the way the world is supposed to be, because that's what Jesus wants us to do. So I forgive you as soon as you ask for it. So right now, my job is to make your ass ask for forgiveness, and I'm going to do my best. Whatever God gives me, I'm going to give to you. Unlawful acts by one, not a notary public. Judah Brokaw. Pay attention. It shall be a misdemeanor for any person who is not duly commissioned, qualified, and acting in the notary public in the state to do any of the following: represent herself or herself out to the public or any person as being entitled to act as a notary public. Well, who is entitled to act like a notary public? A notary public. And what does a notary public do? Notarial acts. So if you're not one, you can't do them. Assume, use, or advertise the title of notary public in such manner. I don't believe you're doing that. Purport to act as a notary public. Well, that is what it looks like you just did. Judith, you're purporting to act like a notary when you don't have a certificate in the county, and you didn't use your seal, and you didn't give us the jurisdiction. This is very sloppy work. I think you need some come to me in a minute. A little more training. What else we got? General Principle 1 sets the tone. I don't remember where this came from, of the entire code. But by identifying the notary as a public official, the principle makes clear that the notary public has certain obligations to the general public. and must fulfill those obligations in a fair, honest, and constitutionally acceptable manner. Consequently, many of the Code's 85 standards direct notaries to execute their official duties consistent with the demands put upon public officers. Public official status. Notaries have the power to impart official imprimatur to a document or transaction. There's a plethora of judicial opinions that declare notaries are public officers. All right, so if you really care about this, stop now and write this down. Brighton versus Nichols, 104 U.S. 757, 765, 1981, blah, blah, blah. But I'm more interested in what does imprimatur means. Permission, particularly that given by the Roman Catholic Church, to publish or print, hence any sanction or approval. Latin, let it be printed. Right? So notaries have the power to impart the Catholic Church's consent to a document. Well, I thought there was supposed to be what about separation of church and state? What about them Catholics? I'm sorry to tell you, man, notaries are as old as the church, and they were the ones who went out and gathered the Acts of the Martyrs. It wasn't gathered, they had a different word. Basically, they're writing down the Acts of the Martyrs. And a martyr was just a witness for Christ, basically. Right? So it's a 2,000-year-old ecclesiastic office. And anybody who's sitting as a notary is holding an ecclesiastic office. And now it's a matter of faith and sin. And these little son bitches are sinning all over the place. But a public official status is different for a notary than many other officials. Unlike some public officials, like elected officers, appointed administrators, or policemen, a notary is not a government employee, per se. They're not doing it as a government employee, they're doing it as a service to the community. The distinction can have far-reaching ramifications, especially in the area of personal liability. Usually, notaries are not afforded the sovereign immunity protection routinely available to public officials acting in the scope of their authority. So quit going after them as a fucking judge. Go after them as a notary. They don't have any sovereign immunity. These classifications, however, are primarily liability purposes and do not detract from the central thesis that a notary is a public official empowered by the state to perform specified duties. The principle identifies a notary as a public as a servant because notarial services are rendered to the public at large under the authority of the state's statutory rules. The principle uses the public servant designation to reinforce the view that the notaries are important functionaries who are obligated to serve individual members of the public. I think that means they got a fiduciary duty. When they're doing something as a notary, it is a fiduciary duty, and the damn shit better be done right. Although notarial acts benefit public at large by fostering reliance on various types of documents and acts, notaries nevertheless are distinguished from other public servants whose primary obligations are to the public as a whole instead of individual members. That's why a judge told a guy one day, I don't have a fiduciary duty to you. As a judge, I guess he would have been correct reading this, right? He said, well, you're a notary, aren't you? Then sure you do. Right? Take my oath. I swear I'm innocent. Additionally, the drafters recognize that a substantial majority of state commissioned notaries are employees whose notarial services are only incidental to their principal job duties, like judges and clerks and commissioners and all the other people. Bank tellers or bankers or title company at the township hall, school district, all these people are notaries. Notaries are public and not private servants. We should use that to our advantage. So, in Michigan, notary complaints. the Secretary of State is responsible for the administration of the Notary Public program. I guess that's the first thing to figure out. Who's responsible for the Notary Publics? Its oversight includes investigating complaints made against notaries. Okay, that would make sense, right? Its oversight includes. So now, does your Secretary of State have an ombudsman? Does your Secretary of State have maybe a
vast virus database has
inspector general? Does it have its own police force like they do in Illinois? I don't know. But in Michigan it says filing a complaint. This is what you do. To submit a complaint concerning a notary public, please provide the following information to the Secretary of State. Via fax, whatever. And you address it to, right? This is the important thing, that not to the Secretary of State, no, to the Michigan Department of State, Office of the Great Seal, with the address. That's who you're, right? That's who you're going to address the thing to. The Michigan Department of State, Office of Great Seal, not the Secretary of State. Your name, address, telephone number, a statement describing the basis of the complaint. Include your signature and date the complaint was signed. I'll have a notary verify it. And then you can tell me if they did it right. Actual record, that is the basis for the complaint, or a copy, photocopy, or other replica of record along with any of the supporting documents. And I wish I'd take the time to find it. I don't know if y'all remember, I did 3 videos about elections, and we were looking at oaths and commissions and so forth for being elected. And it showed the Great Seal of Michigan, or what it should have been, where you should have a moose and an elk facing towards each other in the center with the shield, but the moose is actually looking back over his back, not at the shield. Right? So you would take that, which I probably do now I just thought about it, and send it here to this address. Say, I want you to look at this and tell me if it's proper. Because note, the legality and validity of a document must be determined in a court of law. Notarization itself does not guarantee that the document is true, legal, valid, or enforceable. The legality and validity of a document must be determined in a court of law. Well, you're going to, if you're filing a complaint and you're giving them a copy of it and saying you're complaining about this, and they're going to make a decision, somehow they must be a court of law, because they can give remedial action. Right? If it's not done properly, deny a person's application, issue a letter or censure, require the individual to make affirmative action, including restitution to the injured person, suspend, revoke, impose a fine, require a notary to reimburse the cost of investigation, ask the Attorney General to petition the court for an injunction or restraining order. That could be handy if, some judge is trying to put your ass in jail, and you can say, hey, he ain't a judge because the dude who witnessed his oath wasn't a notary. We need to have an injunction. By law, the Secretary of State may automatically revoke a notary public's commission upon the conviction of a felony, the conviction of a misdemeanor, offenses, blah, 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 blah. In addition, notaries and their surety holders are liable in civil action for damages sustained by persons injured. To pursue legal action against a notary public, contact your attorney, the local law enforcement agency, or the prosecuting attorney's office in the county. For civil action, the criminal action, it didn't say it in here, but in the Michigan law, the Secretary of State is going to contact the Attorney General if they believe there's a reason for right, if there's probable cause, report the violations to the Attorney General or local prosecutor for prosecution. That's what they're going to do. Is there probable cause? Yes. Or no. So, okay, hang on just a second there. I'm going to clear the deck and bring some new things up. Hang on. Okay, this is a certificate authority that Roe got for this. So what was going on is when Roe went to the bank, instead of using something we may have made up in the bottom of the paper, she went in and said, I want you to do it the way it says in the Notary Handbook. And the guy went and got this form, Jurat with the affiniate statement. Right? So if you Google Jurat with affiniate statement, you'll find variations of this for different states. This one here is made up for any state, doesn't have the name on here. But Hey, Roski, they didn't have you sign it either. Look at that. You should have signed this thing. Where's your signature? They didn't let you do this right. You should have signed here. Signature of document signer. So the notary is doing his act improperly. Roe isn't doing anything. Roe says, I want it done by the book. This is the way the notary is doing it. Number one, signature of document signer. They crossed it out. You didn't sign it. He did put a seal, if that's correct, according to whatever, but I'm assuming it is. I'm not going to doubt that the seal's right. I just don't believe they do it right. Then they have this optional stuff at the bottom here. Title of the document, document date, number of pages. Looks like one page. See, now the thing with that is, if this was connected to the document, if it was all stapled together, then it would be a number of pages, because this is just the notarial act for the paper, but it's a separate page. So, should it be 1 page, 2 page, 3 page? I don't know. What I know is the state of IL is not the state that it is. It should be Illinois. It should be the county of Kane. That could be right, but IL. And I don't know if we're going to get to it or what I read, but I think it was actually stuff for California. It said don't abbreviate anything that goes into the official acts book. Right? No abbreviations. And I'm sure, I don't know if it asks for state of Illinois in there or not, but it's not the state of Illinois. It's Illinois. ILLINOIS. That's where it is. And the reason for that is when you go to the certificate authority for this notary, right? It says state of Illinois, county of Kane. But what it doesn't say in here is it doesn't have the words full faith and credit. Right? Here's the certificate of authority again out of the Notary Handbook. Let's see what they did here. Let's see how close it is. Not I, but the county clerk, and for the county in the state of Illinois. Right? It's supposed to have the guy's name here. So Jack A. Cunningham, I think is his name. John, but I think he calls himself Jack. John A. Cunningham, clerk, right? County clerk, right? That would go here. Of the state of Illinois, which office is an office of record having a seal. And keeper of the records of commissioners, notaries, public, do hereby certify that. Man, they're not even close. Right? This certificate of authority that he's giving here is nowhere substantially the same as the following. Record having a seal. Keeper of the record of the commissioners and notary public. Where's the part about having a seal? We don't mean of the records of the commissioners. Office of record having a seal. So this is incorrect compared to this, right? I'm going to say that this here is official misconduct. that it could be challenged with the Secretary of State. Basically, all these things need to be challenged with the Secretary of State because it takes a court of law to determine if it's been done properly. I can't determine it. That these people can't determine it, so they can't tell you they did it right. I can't tell you they did it wrong. The only they can tell me is a court, and the only way to get the court to look at it is to complain to the Secretary of State, at least in Michigan. All right, so this is done wrong. As far as I can see, this dude just committed perjury. Right? It's not state of Illinois or official misconduct. ILLINOIS. Roe didn't sign it. Should be a signature. Signature or document signer. Right? There's the name of the signer, but where's the signature? Now, I know that she signed the other piece of paper. Now, that may be why, because it says, see attached document, notary to cross out lines 1 through 7 below. Okay, that's why. We'll let them off the hook for that. Apparently, you could use this form all by itself if you just had something really short you wanted to do, put it on here, and be done with it. But Roe had a separate page that she signed, so they didn't have her do the signature of the document signer on here. Okay. So again, just based on what the notary handbook says, this certificate is supposed to have, and comparing it to what was given, there's nothing close to being the same. With the name is supposed to go there, not the county clerk. Robert Allen Rutluski, county clerk in and for the said county in the state of, county of Kane, I probably should say, because I think you got to tell them what county you're in. Maybe not. Secretary of State or county clerk of the state of Illinois, which office is an office of record having a seal, certify that whom the foregoing or annexed document was notarized was blah, 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 blah. And the big thing is full faith and credit. Right? Full faith and credit. You want that? You want full faith and credit. Now here it's got Secretary of State or Lee County Clerk. Huh. Why would they pick Lee County? Right now they put a name to it. It's all these strange little things you could scratch your head on for a long time. Let's look at some other oaths. Now, I got this one from Judy K. in Wisconsin. They do a pretty job in Wisconsin. United States of America. The state, Wisconsin. It doesn't say the state of. It says state, Wisconsin. The Office of Secretary of State. Who certifies, keeper of the great seal thereof, do hereby certify that the annexed copy has been compared by me with the record on file in the office, and that the same is true copy. So what we're about to see is a true copy of what is in this guy's office. It got an official witness saying this is what somebody filed in their office. It's oath of office of justice or judge. State of Wisconsin, county of Dunn. Right now, there's that jurisdiction thing, which is probably one of the things that needed to be done. Right? That was, or that's no different than state of Illinois, county of Kane, or state of IC, Illinois, or IL, Illinois. Right? So we'll say that's okay. But now, the term start date, August 1st, 2010. Okay, what day is this being done? The state, state of Wisconsin, received and filed August 24th, 2010. Well, how can this guy be elected and be in office? We're going to read what it says. It says something strange anyways, right? How come they're not getting this to the 24th. When it was done on the 23rd, they waited 31 days before they sent it, and they sent it after the term had started. And right on it, now this is the crazy thing, right? Judge for the Dunn County Circuit Courts, Branch 1, but have not yet entered upon the duties thereof, do solemnly swear that I will support the Constitution, and blah, blah, blah. He's swearing he's not in the office yet. Okay, well, how do we know when he is in the office? It's because he needs to file some kind of acceptance of office or something else. Right? This doesn't say he's in office, right? He's swearing he's not in office yet. On the 23rd, the signature of notarial officer, right? Which this is supposed to be again the chief judge. Subscribed and sworn before me on this date, 23rd. You know, that could be right. I don't know. Type name assigned below, right? William C. Stewart Jr. I don't think that you can do that. You know, I don't know if you can use initials or not when you're supposed to be doing a full signature. But right here it says type name as signed above. And up here the guy put Rod W. something. And down here they got Honorable Rod W. something. Well, Rod didn't call himself Honorable. That's incorrect. Right? They're not doing the simplest notarial act properly. Check one. Right? If you're questioning that they're notarial officers, that's all there are. You have three choices. You're either a notarial officer is a notary public whose commission expires on. Notarial officer is a notary public whose commission is permanent, and that's the one that's been checked twice. Check, check. So Rod W. Smeltzer says that he's a notary officer, a notary public whose commission is permanent. He's got a permanent commission. Excellent. Let's see a copy of it. Or a notarial officer is not acting as a notary public, but is authorized by section something Wisconsin statute with this title, and they didn't do that one. Now in Wisconsin, I believe it says they can or they may use a seal or a stamp. They don't have to, right? But so in a lot of ways, this thing looks like it could be okay, right? But the thing is, it's okay, but it says you're not in office yet. Where's the thing that says you're in office? All they're doing is swearing to the fact that they're not in office, and I think they've done it properly to make sure that they're swearing to the fact they're not in office. And so these kind of things can all be, you know, you can figure the little details out by looking at the election law and what does it take for a judge to be elected a judge. And that's why I did those videos on it's all about elections, because one of the very first things I'll tell you is you got to be a qualified registered elector within a certain election precinct. And, you know, when you go try to do that, they won't let you do it. So I don't know that anybody has gotten it done. I don't get too hung up on that, but, you know, okay, so here's another one that I'm saying this is incorrect because they didn't follow the simple directions. I don't know if the wording is right. What I'm going to show you is that this wording here in these short forms, like in California, says do it exactly the way you see it in the short form. Period. Exactly the way you see it in the short form. Because really this down here is the certificate. This little piece down here below where the guy signed, right? This is the certificate at the bottom. And if I look at, where was that California handbook? Okay, no, it wasn't California. Notary. Secretary of State, Sandy. Ay, 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 ay. Secretary of State, drat. Oh, I hate when that happens. Okay. I guess give me just a second. Okay, we're back. Notary newsletter from California, Secretary of State. That's what I was looking for. Jurat and Certificate of Acknowledgement forms. It is critical that you use the exact wording prescribed by current law when completing jurats or certificates of acknowledgement. If you fail to do so, your notary public commission may be revoked and you may be subject to civil penalties and an administrative action brought by the California Secretary of State's office or public prosecutor in Superior Court. Apparently, it's pretty damn important that you do it the way the law says to do it. And so if we're not sure, because we don't know, see, here's the thing, we don't know. We need to get a judicial determination. Because this is right off the Secretary of State's website in Michigan, right? When you're looking about how you complain for notaries, eventually you get to whatever this is, notary complaints, where it says, note, the legality and validity of a document must be determined in a court of law. Notarization itself does not guarantee that the document is true, legal, valid, or enforceable. So you're going to send them the document, and they're going to take it to court and find out. But that being said, if you haven't done it quite the way that the words say to do, according to California, you may find yourself losing your commission. The notary public can avoid making the 10 most common mistakes identified by the Secretary of State investigators. All right, so apparently the Secretary of State in California is going to take care of notary stuff because he got investigators. Make sure all jurats and certificates of acknowledgement are complete and worded exactly. Complete notarial certificate for every official act. Merely signing and stamping a document is not a notarial act, and stamping pages attached to the page with the completed notarial certificate is not permitted. Right? If they don't do it right, it's their mistake. And so you're going to send it to the Secretary of State to have them review the document to see if the notarial certificate's been done properly. And that could be on the oath to the judge that you're dealing with. It could be on the warranty deed that you're dealing with as far as the property, or any of those other things that have notary seals on that people have always questioned. Well, send it to the Secretary of State from wherever it came from and ask them, hey, was this done properly by your notary laws? Is this correct? Okay, record without abbreviations. All information required by law to be recorded for every notarial act. Right? Record without abbreviation. All information required by law to be recorded for every notarial act. Well, then that dude in Rose's case, I put IL, he's screwed because it was an abbreviation where he should have put Illinois. A person may request a copy of one line of a journal page, which would be useless if that line is filled with an indecipherable abbreviation. Okay, so it says record without abbreviations. He still may be off the hook. This is what you put in the big book, right? In the book, you can request to get that page, that one line from that page. A complete entry is necessary to provide complete record of the notarial act. California law requires you record the following in your journal: the date and time, the type of notarial act that was performed, jurat, acknowledgement, certified power of attorney, the type of document notarized, deed of trust, permission to travel, signatures of every person whose signature has been notarized, details, identification, document, license, passport, excuse me, government agency that issued the identification, the serial number. If one or two credible witnesses were used to identify the signer, if one or two credible witnesses were used to identify the signer, that's if you don't have these things, I guess, of a document, the name of each credible witness, blah, 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 blah. Okay. Anyways, that's just to show you that in California. So in California, go look in the notary handbook and see what the exact words are they're supposed to use for the certificate And if what you're reading isn't exactly the same, brother, you got probable cause to take it right to the Secretary of State investigators, whoever they are. Well, what else was there? Well, good stuff, I'm thinking. So this is out of Michigan's notary law, misconduct, civil liability conditions. A notary public and a notary public sureties are not liable for truth, form, or correctness of the contents of the record upon which the notary public performs notarial act. Right. Not if it's true, not what form it's in, not the correctness of the contents, but they are responsible for the correctness of the frickin' certificate. Damage is sustained by the persons injured. Right? For official misconduct of a notary, the notary and the sureties of the notary public surety bond are liable in a civil action for damages sustained by persons injured. Well, how could you be damaged by a notary? Well, they could improperly do your record so it's not seen as a public record and have any value in court. Because until the court says it's proper, it don't have any value. The Secretary may investigate or cause to be investigated by local authorities the administration of the notary public laws and shall report violations of notary public laws and rules to the Attorney General or prosecuting attorney or both for prosecution. Right? You take it to the Secretary of State, and they take it wherever it goes to. The Secretary may, at his or her own initiative or response to complaint, make reasonable and necessary investigation within or outside of the state and gather evidence concerning the persons who violated, allegedly violated, or is about to violate this act. A rule promulgated under this act, blah, 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 blah. Take your court documents, send them to the Secretary of State, tell them the Notary Act wasn't done properly. See what they say to that. A person may file complaint, against the notary public. Oh, we talked about that. I'm not going to hit all these. The Secretary may impose one or more penalties upon presentation to the Secretary of satisfactory evidence that the applicant or appointment, the applicant for or an appointment or a commissioned notary public has done one or more of the following: violated this act, committed an act of official misconduct, dishonesty, fraud, deceit, or any cause substantially relating to the duties or responsibilities of the notary public. They don't do the certificate right, it's official misconduct. Charge a fee more than was allowed, fail to administer an oath or affirmation as required by law. Okay. So, out of this, in the notary laws of Michigan, where I found that you could file a complaint with the Secretary. And because you could, that's what I'm going to do. And what am I going to use? I'm going to go find somebody's oath and say it's incorrect and send it in and say, hey, I don't think this is right. Doesn't have to have a damn thing to do with me. I'm going to point out the error in the frickin' paperwork. I hope you guys will too. Right? You don't need to ask me what to do. You figure it out. Just go get the piece of paper. Say, hey, this isn't right. Cool stuff. Cool. There may have been one or two other things I want to talk about though before I go. So hang on just a bit. Oh yeah, that's what it is. So what do they have in? So in Michigan, excuse me, I'm supposed to go to the Secretary of State. But in Illinois, now there's a couple of things. We'll go through this one first. Offense Code Book. because this applies to a lot of different things, right? The Secretary of State, State of Illinois, has its own police force. Who would have thought? Secretary of State Police. I believe that this is the jurisdiction that Roe has been charged under on that complaint from Sandy we looked at earlier. That's incorrect. Although it hasn't been done right anywhere, but the Secretary of State, they have their own police. And if we go, I remember the pages, page 46. Because they got it for disorderly conduct, which would be breach of the peace, firearm. I think it was 720 ILCS 5/26-1A1, breach of the peace. So in this jurisdiction, there is such a, right? They call it an Article 26. That's probably what they call it. Violation of Article 26. And they also have one. I mean, again, this is the Secretary of State's police department. They have jurisdiction in commercial bribery, money laundering, terrorism, offenses affecting government functions, treason, interference with public officer. This is the penal code, man. These guys are, right, they're claiming jurisdiction in the penal code. It's all good for me. Outstanding. Official misconduct. That's what we're saying they did. And it talked about in the Illinois Notary Handbook, it was 33-3, which is official misconduct. So that's really all you'd have to put on there is it's a 720 ILCS 5-33-3 violation of official misconduct by improperly notarize performing a notarial act. See attached evidence. That's all you need to tell them. Give them the evidence. Tell them what it is. Copy of a complaint, Exhibit A, and whatever it is. Copy of the oath, Exhibit B. And so they have, and well, they can't make it any easier than they make it. They got an official complaint form. Right, this is, it blows me away. The Illinois Secretary of State Police. This would be like the Inspector General for somebody, I think. This is my point, right? You may have an Inspector General. You may have the police. You may have an ombudsman. You may have somebody called a provost. I don't know exactly how many different things they could be called. But on this one, it's the complaining party, the subject of the complaint, vehicle information, if applicable. Please provide narrative. Affirm. Return to the Illinois Secretary of Police. And there's two of them. There's one, I think, in Chicago. It's like, there's 4 districts. That's what it was. There were 4 different districts. Anyways, Rose said she found that she can actually do this online, but I'm just pointing out that, number one, the Secretary of State has his own police force in Illinois. You may want to get to know it, because the Secretary of State has jurisdiction over notaries, and we want to point out official misconduct, which you will find under Article, I don't remember, 48. Article 33. Okay, because that's what this is. All these different articles, and then they have the 533 and all the different ones. All these this is all out of the penal code. Public contract, man, you could find all sorts of shit in here. Wow. They've told us before we're supposed to take our complaint to the police, and it looks to me like the police they're talking about in Illinois is the police that work for the Secretary of State. Get them for I saw treason on here, for God's sakes. Yeah. Article 30, treason and related offenses. Treason, misprision of treason, advocating the overthrow of the government. Put a charge like that on and see if it gets a rise out of them. So, that's it. I'm done talking for today, but I hope you understand that there's something to do with the notary, and when we understand what it is, and we go ask some simple questions, which I don't even know what they are yet. I got an idea what a few are. But you don't want to go after them as a judge or a mayor, or no. You're going after them as a notary for the things we're talking about that have to do with this paperwork, right? Way back at the beginning of this yakking today, when I showed, I don't think it matters which one. We'll look at another one if I find one here. Patrick sent me this one. City of Flint. Alright. City of Flint has a seal. The seal wasn't used. Whoever this is committed perjury. And I bet that this guy here, whoever this is a notary. Right? Because these come out of the finance department, and it's probably somebody who's a notary within who just basically committed perjury as well. I can't say he did it as a notary, but he did it because he is a notary. He has a fiduciary duty to the public, individual, and you asked for this, and he gave you a fraudulent document. Right? He didn't do it as a notary, but he gave you a fraudulent document anyways, or he did do it as a notary. I don't know how you would look at it, but I'm going to say that a notary, isn't upholding the office of notary, and they don't have, and notaries don't have any sovereign immunity. Right? So I'm not going to say they were a judge. I'm going to say they were acting as a notary. That should make a pretty interesting week. Okay, if you can donate, please do. Please go back to the beginning. Just watch the beginning real quick and. Yeah, help me out. Appreciate it. Y'all have a great day. See ya.